Mr. Morehouse, the floor is yours.
Thank you, Mr. Chairman, and to the committee for inviting me here today to share my expertise and my personal experience on the ongoing crisis and crime of international parental child abduction in Japan. Japan is internationally known as a black hole for child abduction. To date, as you mentioned, there have been more than 400 U.S. children kidnapped to Japan since 1994, and the government of Japan has not returned a single American child to an American parent. Over the years, many Japanese citizens and officials have shared with me that they are deeply ashamed of these abductions and need help from the U.S. and other countries to change it. They've asked for continued public foreign pressure as it gives them the support needed internally to uproot this cabal of resistance in Japan that continues to corrupt the family court system there. This is revealed in itself in what's called the continuity principle, or simply put, judges and attorneys representing abductions and abductors, and they manipulate the best interests of the child to rule that the child should remain alienated and ignore how they ended up with the abducting parent. When Japan acceded to the Hague Convention on the Civil Aspects of International Parental Child Abduction in April 1st, 2014, you, Mr. Chairman, you joined us as we met with the Japanese ambassador officials at the embassy to discuss their plans for implementation. And I remember walking out of that meeting, knowing that our worst fears had been realized. They had no real plan to uphold the spirit and the intent of the Hague Abduction Convention. It was all misdirection, all smoke and mirrors. What we foresaw then remains true today. Under Article 21, and I'm quoting here, it says, "The central authorities are bound to promote the peaceful enjoyment of access rights and the fulfillment of any conditions to which the exercise of those rights may be subject. The central authorities shall take steps to remove, as far as possible, all obstacles to exercise these rights." In the first known case to pursue Hague access rights in the Japanese courts, Canadian Henrik Teton requested interim access to his children and was ignored by the court. The judge refused to provide his name, therefore making accountability in these rulings impossible. No observers, no embassy officials were allowed to witness the court proceedings. 4.5 years ago, at the very moment Japan acceded to the Hague Abduction Convention, parents joined Bring Abducted Children Home to hand-deliver 30 Article 21 access applications. Hague was supposed to be an efficient path to see our children again. We were told at that time we must give Japan time. We must wait and see. Well, we've waited and we've seen. Of those 30 cases, 3 parents reported receiving 1 Skype session with their children, and 1 reported 3 sessions before the kidnapping parent cut them off entirely. None of these parents have received true unfettered access to their kidnapped children. When I personally filed for access under Article 21, my ex-wife responded by filing a new motion for custody in Japan, citing my Hague application and weaponizing it against me. I had to put my application on hold for 3 years. After winning my case in Japan in 2017 and attempting to restart efforts for access, she's been non-responsive. In consultation with the Japanese Central Authority, the Office of Children's Issues is again encouraging me to file an Article 21 motion in the Japanese courts. This is grossly flawed. As I'll state later in my testimony, Japan now admits that all power to comply with court rulings rests with the kidnapper. Japan's implementation of the Hague Abduction Convention is an abysmal failure. Hague return orders have failed to be enforced time and again, although it states under Article 7 and I'll quote again, "Central authorities shall cooperate with each other and promote cooperation amongst the competent authorities in the respective states to secure the prompt return of children." The prompt return of children. It doesn't state the optional return of children. Japan fails miserably here too. The enforcement of the return orders fails every time unless the kidnapping parent willingly complies. Now, in Japan, an enforcement involves an official going to the home and asking for the children to come out, while the kidnapping parent remains inside, prompting them to stay and holding all power over those children. For James Cook, as the chairman mentioned, he testified to this subcommittee in April. Japan's courts overturned the return order because Mr. Cook had moved into an apartment and had to share a bedroom with his sibling after the enormous legal bills incurred from years in fighting in the Japanese courts. He took his case all the way to the Supreme Court of Japan, and the Hague Convention failed again there. Laws and treaties are being ignored. Mr. Cook's children remain abducted with the kidnapping parent. This is just another example of Japan's continuity principle at work, and it crushes any hope of reuniting with our kidnapped children. According to my discussion with the State Department, Mr. Cook's case would now be classified as a judicial resolution under their interpretation of the Goldman Act. In other words, Japan gets rewarded for finding a way to avoid returning children that are kidnapped from the United States. It's another example of Japan's systemic failure to return kidnapped children. It involves two Japanese parents that were living in the United States. I point this out because it's the second time that a case involving two Japanese parents received extrajudicial effort that I have not yet seen in cases involving a non-Japanese parent. Like in the Oregon case that ended in 2016, the enforcement of the Hague return order failed. In this new instance, a Japanese form of habeas corpus petition was filed in the Nagoya High Court, but it was not awarded. So the father appealed to the Supreme Court in Japan, which issued a ruling in March 2018, and they wrote 4 significant points in that. The child was found to be unduly controlled and influenced by the mother. The second point, therefore, the child's statement was not considered to be objective. The Supreme Court in Japan determined that the retention of the child was clearly illegal. And then the Japan Supreme Court remanded the case back to the Nagoya High Court, the lower court. In effect, the Supreme Court issued an opinion, but they didn't issue a return based on habeas corpus, which evolved out of this failed Hague process. Now, in July 2018, the Nagoya High Court issued a new ruling in the case. This time, the child was ordered returned, but the mother and the child immediately fled the court. It can be assumed that the government of Japan, the courts, her attorneys, and the police know exactly where the mother and the child are. But the enforcement of the return order remains to be executed. In 2014, the Goldman Act was signed into law in part to create accountability for countries like Japan that fail to return our kidnapped American children. Multiple tools were provided: a démarche, an official public statement, public condemnation, denial or cancellation of official meetings or state visits, the withdrawal, limitation, or suspension of U.S. assistance, and a formal request to extradite the kidnapping parent. To date, only démarches have been issued. All other tools have been ignored. While we still don't have a single case of the government of Japan returning an American child to an American parent. In April, the Senate Judiciary Committee took this topic up at a hearing. Senator Booker asked, and I'll quote, "Are we using the tools in the Goldman Act beyond démarches? Assistant Secretary Carl Risch of Consular Affairs responded, quote, "Not to my knowledge." Chairman Grassley inquired, "How many démarches have been issued since the passage of the Goldman Act?" Mr. Risch, "There have been many, but we feel that type of diplomatic engagement is the key to success in these cases." Senator Blumenthal probed, "Have you used any other tools?" Mr. Risch concedes they have not. In response to the committee's follow-up questions for the record, Assistant Secretary Risch responded that from 2008 to 2015, 9,127 children were kidnapped, and only 3,992 were returned. There was no substantial change in the percentage in those 8 years. Some years it went up a few points, some years it went down. If returning kidnapped children home to the United States is the key measure of success, and it is, that would point to a failure in strategy, not success. This subcommittee in April also held a hearing that examined the lack of use in the tools, and at the hearing, Chairman Smith, you noted that since 2014, we've seen a decrease in the number of new abductions, but not an increase in the percentage of returns. And you noted that in your opening statement as well. Special Advisor for Children's Issues, Suzanne Lawrence, testified, and I'll quote from her, we do consider all the tools we have at our disposal, and we do that with our interagency partners and try to use the best tool at the best moment on a case-by-case basis. We consider them when we think they will be effective. Congresswoman Jayapal followed up, what would move the threshold in order to use those tools? What can we tell our families about what we're going to do differently than we've been doing now? Ms. Lawrence replied, I don't have a specific answer for you on what the threshold is. Congressman Harris commented, is it going to take literally an act of Congress and an appropriations bill to get you ramped up through the escalating sanctions that can occur in some of these countries that the State Department has been unwilling to pursue? And Chairman Smith, you hit it right on the mark. Sanctions work. If Japan doesn't get it through your persuasion, and I thank you for trying so hard, it's time to lower the boom. And the State Department's response to those hearings was to ignore Congress's call to use the tools. A comprehensive review of all 4 actions reports from 2015 to 2018 shows a very bleak pattern. Many of these countries cited are repeat offenders, yet no other tools other than a démarche was utilized. Japan had 3 démarches in 2017 alone. In fact, other tools were only mentioned one time. In the 2018 actions report, the department, they claimed, the department wrote, the department is considering the use of further tools under the Act if Japan continues its pattern of noncompliance in failing to promptly enforce convention court orders. In an open session of the Diet in Japan in early 2017, the Japanese foreign minister at the time, Fumio Kishida, declared, there's not a single example of sanctions under the Goldman Act. He called them out. He called the State Department's bluff. Through multiple hearings in the House and the Senate, the State Department has rejected your calls, Congress's calls, to use the tools. Clearly, démarches, raising IPCA cases with foreign government officials, and empty threats are not bringing children home. And what are these démarches? What's in them? Does anyone really know? I'm still waiting for a response to a FOIA request that our organization submitted in February. What is it going to take beyond démarches? When are the interests of American children that have been kidnapped going to be put first? And when will decisive efforts be made to bring abducted children home? Based on multiple discussions with state, it's clear that Japan anticipated being cited in 2018. It started at least 6 months in advance. There was a démarche in November of 2017 and December. Japan knew what was coming, and they were preparing to spin their way out of it. On May 15th, 2018, as Japan was about to be cited for international parental child abduction by the United States, they held a public seminar at the House of Culture in Japan in Paris, co-organized by the Ministry of Foreign Affairs of Japan and the Japan Bar Association, Federation of Bar Associations. An audio recording of this event from inside, we hear participants being educated about the Hague Abduction Convention. They are taught how to prevent having their children returned to France, should they be taken, without consent to live in Japan. More simply put, the organizers lay out how to abduct to Japan and get away with it. By creating a seminar that advised potential abductors how to circumvent a Hague return order, the government of Japan has exhibited a shocking and blatant disregard for this international agreement. When they were exposed and confronted by French Senator Richard Young, Japan's Ministry of Foreign Affairs tried to deflect it as a rogue act by a presenter they invited. Now, if that were true, somebody from the Japanese government staff would have immediately interrupted at the seminar and disavowed their government of this. They would have denounced it right then and there. They didn't do that because it wasn't a rogue act. It was intentional. The government of Japan is a shameless co-conspirator. I'll note that seminars continue to be held, and there's little reason to believe that the content has changed. There was one scheduled in London, and I believe there was another one scheduled in New York. In June of this year, just after Japan was cited by the United States, their press reported potential draft legislation to purportedly address the child abduction issue. This was an attempt to change the narrative. It noted that there is nothing under Japan's legal system to deal with parents who refuse to hand over their children in defiance of a court order. The proposal on an interim report considered fining parents to encourage them to voluntarily comply. Now, fines and voluntary compliance already exist, and they haven't solved the problem. Fines can be levied, they can be imposed, but they have to be collected and substantial enough to bend a kidnapper's will of defiance. That's a very narrow and unique set of circumstances. It's not a judicial or legislative reform. As this potential draft limped along in September, it was reported in the press, the rules now call for giving more power to enforcement officers and allowing handovers to take place in the presence of parents with custodial rights. On condition sufficient consideration is paid to the sentiment of the children. We've got to unpack this a little bit. It sounds good, but there are two immediate problems with it. First, a Hague case has to do with habitual residence, not custodial rights of the child. There could be a parent seeking a return order that might not have sole custody or the recognition of being the custodial parent in Japan or under Japanese law. It's habitual residence that we're dealing with. Second, what is it that they mean by sufficient consideration paid to the sentiment of the children? It's another loophole. What is the sentiment of a child going to be after they've been alienated for months or years? They're going to be filled with confusion, fear, anger, anxiety, all directed at the parent who's here to take them home. Is this, quote, sufficient consideration going to dictate enforcement is still abandoned because the child appears more accustomed to living a life under duress? These are subversive efforts to give the false impression of progress in Japan. It's more smoke and mirrors. Though the State Department has put great hope in Japan's potential legislation, a recent discussion I've had with them reveals that they were working on a draft from the summer, not the current legislation. The current potential legislation. It's not even a bill yet. The current version, according to our partners, have gutted the bill and would be completely ineffective if it's ever passed in a year or years down the road. So don't be misled by reports in the Japanese press and from State Department meetings with the government of Japan of sweeping legislative changes to improve our kidnapping crisis. Japan should not be rewarded with more time to fix problems that were exposed years ago. Let the kudos come after our kidnapped children are returned. In May, my colleague and I met with Japanese embassy officials to try and better understand, is there any genuine path for Japan to reunite parents with kidnapped children? The head of Chancery, which I think is essentially their number 2 person there, Mr. Takuya Sasayama, was shockingly candid to us. He said, your access depends on the mother and the child's wishes. In November, the State Department met with officials in Japan at the Japanese Central Authority to again raise cases of American children kidnapped to Japan and the lack of progress and failures in enforcement of judicial rulings. 2 weeks ago, I received a comprehensive readout from the Office of Children's Issues on this, and there were 3 points I want to share with you. Japan acknowledged that 1, if the parent refuses, there are no repercussions for ignoring an application for access, a return order, or a court order. 2, enforcing a court order depends on the voluntary cooperation of the kidnapping parent. And 3, the kidnapping parent knows this, and they hold all the power. Is this Japan's new tactic? Admit the problem and blame the kidnapper? We need real solutions to the numerous clear-cut cases, such as Naval Captain Paul Toland and Paul Wong. Though they're both the only living parent, the grandparents in Japan are holding their daughters from them. There are cases like Randy Collins, whose ex-wife was ordered to surrender the child's passport to the court, and instead she kidnapped him. Douglas Berg's children were kidnapped from their habitual and legal residence in the United States in 2009, violating his parental rights to access. Marine Corps Sergeant Michael Elias' 2 children were kidnapped to Japan after a U.S. court ordered no travel for those children. The list goes far on and on. It's far too long. All children and families crushed by the government of Japan's unwillingness to uphold its moral, ethical, and treaty obligations. There are thousands of cases within Japan that must be remembered too in this process. In my own case, I was granted sole custody of my son in the state of Washington in May 2007. 3 years later, on June 20th, 2010, I dropped my son, Mochi Atomu Imoto Morehouse, off to begin a week-long visit with his mother. He was 6.5 years old at the time. This is where my nightmare began. 6 days later, I received a phone call that no parent ever wants to receive. It was the police. My son, my ex-wife, had been reported missing. I knew immediately what had happened. She had succeeded in what she'd been planning all along. She had kidnapped our son to Japan. At this moment, my life had been shattered. I did everything I could to prevent this. There were passport and travel restraints in place. I had a court order that barred her from leaving the state of Washington with him. The Seattle consulate of Japan had denied her passport request when she went there, and she simply went to the passport office at the Portland consulate of Japan, which issued her one, in violation of the Ministry of Foreign Affairs' own policy. Over the years, some people have said to me things like, "At least you know he's safe with his mother." He might be somewhere in Japan, but he's not safe. He's at risk. He's been willingly and intentionally kidnapped to a foreign land with the intent of alienating him from me and everyone he knows. Imagine being a small child and your mother steals you away to a foreign country and tells you your father doesn't want you anymore or he's dead. Your whole life is now built on a foundation of lies. This is not what a healthy, nurturing parent does. It's child abuse. In 2014, and again in 2017, I won another landmark ruling in Japan. The court declared my U.S. sole custody order has legal effect. My ex-wife has no legal custody rights in Japan. None. They also cited her admission of illegal acts of passport fraud and forgery. There was no intent to offer justice, though. It was simply the continuity principle at work again. Doesn't matter how a child ends up with an abductor. Japan will not uphold laws and treaties to return children to their rightful home. In the end, the court refused to even reunite Mochi and me. I don't even know where he's being held. Our kidnapped children's true voices have been silenced. They need to be heard. In the beginning of my most recent legal battle in Japan, my son, 13 at the time, was asked by his attorney, "Do you ever think of your father?" And he replied, "Sometimes I dream of him at night," as he cried, telling that lawyer, "The last time I spoke to my son, the last time I saw him, was on Father's Day of 2010. I love you, Mochi, wherever you are. On behalf of the 66 children listed on the Back Home website, and those who have all been rendered voiceless by their abductors, for my fellow parents of internationally kidnapped children here today and watching all over the world who feel marginalized by the lack of active, engaged, transparent assistance in recovering our loved ones, I implore Congress to take strong, unified action toward Japan for its ongoing refusal to return our kidnapped children. For the past 2 years, Prime Minister Abe has spread it all over the press how President Trump and the U.S. are going to help Japan resolve the 1977 to 1983 kidnappings of 17 of their citizens kidnapped to North Korea. I feel for those parents. I understand their pain. It's our pain. And the U.S. should help. It's the right thing to do. President Trump ran on putting America first. Well, putting America first means putting America's kidnapped children first and bringing them home. Prime Minister Abe, what about returning the 400+ American kids kidnapped to Japan since 1994? What about returning Mochi? The government of Japan throwing their arms up in the air and saying, it's up to the kidnapper. It's not acceptable. The government of Japan is complicit here. Last week, Secretary Pompeo said to the German Marshall Fund in Brussels, when treaties are broken, violators must be confronted, and the treaties must be fixed or discarded. Words should mean something. How will Japan be confronted? In September, the President addressed the United Nations and declared, quote, "We're standing up for America and the American people." Who's standing up for America's kidnapped children? Words must be backed up with actions so that Japan will recognize that enough is enough. And the United States will not tolerate the ongoing kidnapping and retention of our citizen children. In Vice President Pence's press statement from his November trip to Japan, he stated to the Prime Minister that President Trump has made a commitment to, quote, "speed up the sale of defense technology to Japan." And we're keeping that promise. Before the end of the year, we will deliver 10 F-35s to Japan and 6 more in 2019. I urge Congress to take immediate action while the opportunity exists and block the sale of defense technology to Japan until our kidnapped children are returned to us. They've broken their treaty obligations. It's necessary to stand up for the American people here. Create the sanction, please. Stop the delivery of the F-35s. Tell the Prime Minister it is not acceptable to continue to hold my son, Mochi, Atomu, Imoto, Morehouse, or any of the 400-plus American children kidnapped and retained in Japan.
Mr. Morehouse, thank you very much for that very persuasive testimony on behalf of your son, as well as all the other left-behind parents who are being, I believe, cruelly mistreated by the government of Japan. Thank you so much.